Good morning, everyone. Welcome to today's hearing. Well, today we begin our last set of hearings, during which we're going to hear final closing statements from a number of the core participants. And we're going to start with Ms. Barwise, King's Counsel, on behalf of the bereaved survivors and residents whom she represents. And so she's there ready. No rush, but we're ready to hear from you when you're ready, Ms. Barwise.
Good morning, sir.
Good
morning, Mrs. Stefan. Good morning, Mr. Ackworth. We end phase two very much as we began it, in the sense that few core participants accept significant responsibility for what happened. The Department for Levelling Up and RBKC do acknowledge their significant errors, but otherwise introspection is lacking, apart from those who admit historic but non-causative mistakes. Self-interest is unhumbled by the disaster and indeed by this inquiry. The leitmotif of Grenfell is the failure of anyone to take responsibility, either then or now. Other than central and local government, no core participant accepts any responsibility for the disaster, each instead seeking to diminish its own role. Each core participant continues to blame others and predictably now blames the regulatory regime for its permissiveness and tendency to be abused. This is to overlook that the designers and contractors of Grenfell all failed to address properly what the statutory requirements actually were and use a system including foam insulation, patently in breach of the linear route, which was the only route to compliance they could have been following. Whilst, of course, the building regulations were an outcomes-based regime at the time, it was still necessary to demonstrate compliance with the functional requirements to the building control officer. Each of the designers and contractors were untroubled both by what the regime required and whether they complied with it. Manufacturers were all too aware of both the functional requirements and ADB, but sought to circumvent ADB's linear route, which prevented the use of their products. Pausing there, Arconic well knew that its ACM PE, once made into cassette panels, did not even conform to ADB's diagram 40, because it was neither class 0 nor B. The entirety of the cladding system at Grenfell did not conform to the linear route. Yet Arconic's BBA certificate applied to both riveted and cassette panels. When we say little has changed since the beginning of phase two, we mean that, incredibly, Arconic remains in denial as to the lethality of its ACM-PE product. Studio E, although silent in this round of submissions, when it last spoke, inaccurately sought to minimise its central role as lead designer. Exova makes no mention of its own failures to produce an adequate fire safety strategy, nor the fact that its strategy was misleading, both on the subject of the cladding and means of escape for disabled people. Harley, who shamelessly drove the use of ACM's PE product at Grenfell for illicit profit, which it shared with Ryden, expresses dismay that manufacturers were able to take advantage of flaws in the regulatory system and insists industry at large did not know ACM PE to be unsafe in fire. This submission is brazen, given Harley well understood ACM PE was highly combustible. One of its own designers contemporaneously said, as we all know, ACM will be gone rather quickly in the event of a fire. BRE argues that if regulations had been complied with, intolerable fire spread would not have occurred. That may be true if the BS 8414 route had been utilised, but not if the linear route was followed, but without due regard to the functional requirements. BRE also defends its desktop assessment, criticised by Professor Bisbee. NHBC, in misplaced reliance on Professor Bisbee's desktop report, seeks to justify its irresponsible role in jointly producing Technical Guidance Note 18, which introduced the concept of facade desktops as a route to compliance. We are acutely aware that the panel must examine all the circumstances of the disaster, including both the immediate causes of fire spread and subsidiary causes which exacerbated the consequences of the fire, such as lack of means of escape for disabled people and the general management and maintenance of Grenfell. Indeed, we've encouraged and continue to encourage the panel to address even issues which were insufficiently causative, such as poor workmanship during the refurbishment, or not directly causative, such as dishonest marketing by the insulation manufacturers, together with the BS 8414 testing regime and supervision of it by UCAS. It is clearly vital to explore the role of insulation manufacturers, despite their products not being responsible for the uncontrollability of the fire. Whilst we did not suggest Kingspan's K15 product was causative at Grenfell, we had characterised Kingspan's behaviour as seminally causative, and we remain of the view that they and Celotex were seeking to misrepresent to the market that foam insulations were universally safe for use at height, to overcome the prohibition in the linear route of ADB. As Kingspan acknowledged in its 2015 Reasons Why campaign, it was seeking to instill confidence in K15 used in buildings with a habitable story 18 metres or more above ground, and to prevent increasing specification of rock wool, and to spin such that the story is not fire, fire, fire all the time. It wanted to educate the market as to the insignificance of combustibility of individual products in the overall scheme of things. Even in the immediate aftermath of Grenfell, before it could have known whether its product had been causative to any degree or not, Kingspan sought to educate government by its political campaign to demonstrate materials of limited combustibility would fail. Kingspan did this by its subsidiary Euroclad building weaknesses into Kingspan's tests of limited combustibility products. This was not honest science. It was seeking to manipulate the impact of the government's building safety tests. Kingspan should take little comfort from its K15 product not being the catalyst for fire at Grenfell becoming irreversible, by comparison with a product whose core equates to diesel or lighter fluid. The evidence should not be seen as universally vindicating the use of foam insulations. First, according to Bisbee, K15 may have been relevant in initial escape from flat 16 due to its ease of ignition, and K15, unlike RS5000, produced burning debris. Second, Bisbee is clear that K15 might be causative in other cladding configurations, and these should be considered. Given the Phase 2 experiments show K15 is easily ignited and combustible, one might question its use in both timber-framed buildings and buildings using structurally insulated panels. Similarly, as Grenfell's cladding was not subjected to a BS 8414 test, it might be argued, and BRE does argue, that it is not for the inquiry to consider such testing. We disagree. Both the testing and certification process should be examined. It became clear in Module 2 that the whole certification regime by bodies such as BBA and the veneer of supervision of those bodies by UCAS is in itself part of the problem. Despite that invitation to the panel to explore all such avenues, non-causative in the legal sense, we have nevertheless sought in our written submissions to identify the principal effective causes of the disaster so as to arrive at a minimalist rogues gallery, by definition not definitive. Given the scale of the disaster and the number of those who died, it is vital the inquiry ascertains the principal effective causes, so that those most accountable are identified and to prevent recurrence by targeted and robust recommendations. This is the least that the bereaved and survivors can expect of us. Identifying the actual causes of the disaster is necessary for catharsis and to prevent distraction by false narratives, which are dangerous in that they distort or conceal the steps necessary to prevent recurrence. Before attempting to allocate responsibility, there are certain implications of an outcomes-based regime which were made clear in the Module 7 evidence and which influence responsibility. First, as Professor Torero told the panel, the fire safety engineer bears a pivotal responsibility for for safety in that it is their job to explain the functional requirements, including those for B4, external fire spread, within the fire safety strategy. This includes defining what adequately resist fire spread means and explaining what, if any, degree of fire spread in the external walls is acceptable. This task is building specific and influenced by the evacuation strategy. In the case of a high-rise building with a stay-put strategy, no external flame spread can be tolerated. Thus, the fire safety strategy is the blueprint for a building's fire safety and demonstrates compliance with the functional requirements. Second, it is incumbent on designers and contractors, whether following the linear route or test route within ADB, will achieve compliance with the functional requirements. Implicit in this is that neither routes to compliance with ADB nor the BBA certificates demonstrating conformity with tests can be slavishly adhered to without the designer applying their own judgment. Third, whilst desktops, in the sense of legitimate engineering assessments, were always a means to compliance with the functional requirements, the concept of facade desktops was introduced and expressed to be a third route to compliance with ADB, not by government, but by BCA's TGN, drafted by industry. Whilst Professors Torero and Bisbee rightly stress the outcomes-based nature of the regime, the reality of ADB was that it was intended to be, and was, wrongly as it transpired, regarded as a safe harbour, namely a reasonably safe way of achieving compliance with the functional requirements. Whilst there were caveats within both the building regulations and ADB to the effect that the approved documents were not a guarantee of compliance, nevertheless, partly through ignorance and partly as it suited their purposes, designers and contractors over-focused on ADB as a safe route instead of considering the functional requirements. Two important issues on which the panel may wish to make findings are first that the fire safety engineer's failure to define the functional requirements in the fire safety strategy was not legitimate, and second, that designers and contractors' reliance on ADB without the exercise of judgment and reliance on BBA certificates without interrogation was not legitimate. The panel should bear in mind, when reflecting on whether to hold a Phase 3 on its proposed key recommendations, as some suggest, that there are several areas, this is but one, in which the panel will have to find groups of stakeholders in a given field acted in a way which is not logically supportable. This narrows yet further the field of those able to give reasonable, unbiased input to the inquiry. There will be no shortage of tendentious arguments against sensible recommendations. In our ranking of responsibility, we split the protagonists into three groups. First, those with responsibility for speed of fire growth and spread, namely those responsible for the use of ACMPE. Second, those with responsibility for contribution to spread of toxic smoke due to poor compartmentation. Third, responsibility for failure to ensure adequate means of escape for disabled people. The need for concomitant PEEPs is addressed by others. In our first group, those responsible for the selection of ACMPE, we split the protagonists into two groups and ranked them in order. First, Arconic, manufacturer of the ACM panel material. Second, Studio E as lead designer and architect. Third, Exova as fire engineer. Those bearing secondary responsibility are Harley as cladding design subcontractor, Ryden as design and build contractor, RBKC building control, and government as custodian of the statutory regime. Arconic still insists its product in rivet form, achieving a Euro Class B, despite subsequently achieving as low as an E in cassette form, means its product was theoretically safe. Arconic invites you to conclude there was nothing irregular about the test by which the B was achieved, on the basis of Mr. Burnham's statement that although the air gap may be an important parameter, there is no unequivalent correlation between the air gap and performance. Arconic's submission completely ignores Mr. Vehler's contemporaneous email saying that the test in which a B was achieved for the riveted panel was arranged to pass, and overlooks Arconic's own evidence that the 50mm gap tested was unrepresentative of the gap used in practice. More fundamentally, Arconic sidesteps the fact that its BBA certificate deliberately gave a wholly misleading impression as it related to both cassette and riveted panels. Arconic's argument that the material itself, before fabrication into panels, was capable of achieving a B, therefore comes to nothing. Arconic argues it is wrong to equate its product to petrol or other fuel, given Bisbee and Torero's experiments show that without the cavity and insulation, ACMP would self-extinguish. Given most cladding systems comprise both the cavity and insulation, Arconic's point is clearly bad. It ignores the inquiry experts' findings that the PE core is a highly volatile material. Once the aluminium skins delaminate, PE core is a catalyst for an uncontrollable fire. Studio E, as lead designer, bears the ultimate responsibility for the selection of ACMPE. The NBS specification it drafted, predominantly in proprietary form, was designed to ensure its aesthetics were achieved without considering fire performance of the cladding panel. Studio E never considered the functional requirements for the external wall, and the route to compliance was nowhere stated. Studio E should, according to Mr. Hyatt, have reverted to Exova to produce the B4 analysis of the chosen system. The lack of thought by Studio E as to whether and how the selected rain screen met the functional requirements was evidenced by Soon's failure to read beyond page 1 of the BBA certificate. He never attempted to ascertain ACMP's performance in fire. Exova ought to have produced a fire strategy which explained how the functional requirements for the external wall were to be met by determining what, if any, fire spread was tolerable within Grenfell's facade. Instead, Exova gave no guidance, but created a false sense of security by saying the proposed changes, which it knew involved cladding, would have no adverse effect. This set a complacent tone for the fire safety from the outset. In Exova's subsequent and ad hoc involvement on the project, it became aware that combustible insulation was proposed, yet at no stage did it intimate that it now needed to carry out an external wall analysis, nor question what route to compliance was being followed. Given Exova was reputedly a top-tier fire engineer, had it examined the chosen cladding system and advised Studio E that it was non-compliant, it is likely Studio E would have changed the system. Given Exova's primary business was fire testing and research, of which the consultancy division was merely a part, Exova should have been aware of the dangers of unmodified ACMPE. Our second group is led by Harley, also untroubled by compliance. Harley's subcontractor designer, Mr. Lamb, failed to check whether ACMPE was compliant with the functional requirements and ADB, and did not even read the BBA certificate. Harley seeks to limit the importance of its role to mere cladding subcontractor, but the letter of intent against which it worked recorded the subcontract was for the design of the facade works. It avails Harley nothing to suggest, as it does, that it was merely a labour-only subcontractor as opposed to a designer. Nor is it of great significance that the contract was not signed. It was clear from the documents Ryden and Harley exchanged that a contract for the design of the cladding had been made and a price agreed. Harley clearly undertook a degree of design by its Mr. Lamb. As such, Harley owed a duty to warn if the NBS specification was patently defective. Second in our Group 2 lineup is Ryden, who as design and build contractor clearly had a responsibility to at least check compliance of the facade, but failed to do so, and also selected the UPVC window surrounds, which permitted the fire to escape so easily. Third in Group 2 is RBKC Building Control. Whilst the disaster would not have happened without the acts and omissions of the construction professionals and manufacturers, it is conceivable that it could have been avoided if building control had identified the non-compliance of the cladding system. That said, building control is only likely to have noticed the insulation was non-compliant, and even had it required a change to mineral wool, the disaster would still, based on the Phase 2 experiments, have occurred. Ms. Menzies, however, considers Holborn should have interrogated the BBA certificate and established that the panel chosen at Grenfell was not Class 0. Even had Holborn identified both non-compliances, it is likely, given the permissive nature of building regulations and given the design team's financial motivation to use ACMPE, that the team would have persuaded Holborn the design complied by some way other than compliance with the linear route, possibly by desktop. DCLG's Martin was, after all, contemporaneously concerned that BCOs would be swayed by dubious desktops. Whilst the contractors and designers all claim it was building control's role to be the final arbiter of whether compliance had been achieved, this is neither sensible in practical terms, nor is it fair. Contractors and designers are generously paid to focus on whether the building, including its facade, is compliant, whereas a local authority has to consider many buildings, and its staff are necessarily not the same calibre as highly paid, highly specialised designers and contractors. Historically, the courts have considered local authorities are not underwriters of building projects, and that seems correct. Whilst we do very much criticise RBKC building control, we do not consider they are as culpable as the manufacturer, architect, fire engineer and contractors. Last in our Group 2 lineup is government. Clearly, as the Department for Levelling Up admits, the department facilitated the disaster. But the real questions are whether the department could and should have acted earlier, and if it had, whether it would have prevented the disaster, given the many deceptions practiced by industry to circumvent even those elements of ADB which were clear. Some of these deceptions came even after Grenfell, showing some industry protagonists' unswerving commitment to circumventing inconvenient regulation. These practices included manufacturers' deceptive marketing, extending to corrupting BBA certificates, the production of self-serving guidance, such as TGN 18, using desktops to circumvent ADB's linear and test routes, Kingspan's post-Grenfell myth-busting campaign against non-combustible products, and NHBC's 2016 guidance approving a build-up of ACMPE and combustible insulation. I now turn to responsibility for exacerbation of the consequences of the fire. Primary responsibility for this falls into two categories: those who caused or contributed to poor compartmentation, and those who failed to ensure adequate means of escape for those with disabilities. As to compartmentation failures, these are attributable to a variety of factors, including doors, the installation of the gas pipe in the stairwell, and breaches in compartmentation caused by the smoke control system. Responsibility for lack of operational door closers falls on RBKC and TMO. There was no system of planned maintenance or routine inspection of the doors, and RBKC's Laura Johnson rejected an annual door closer inspection programme on grounds of cost, despite LFB having required it. This conscious cost-benefit analysis, with human life as the cost, was not a legitimate way for a local authority to behave. Johnson should have sought increased funding and stressed to her superiors the gravity of the situation. TMO simply went along with RBKC, despite understanding the importance of a door maintenance regime to life safety. TMO also bears responsibility for failure to ensure rectification of unsealed holes in the compartment walls made by pipes for the new gas supply, about which it had been warned. The designer of the smoke control system, PSB, bears responsibility for breaching compartmentation via the north and south shafts of the system. PSB's failure to appreciate that the shafts were protected shafts is a fundamental and serious issue, compounded by PSB's specification of substandard dampers. The dampers should have been smoke control dampers, but instead were fire dampers, the lowest possible standard. The panel should disregard PSB's attempt to blame lack of clarity in the regulations and to assert that functional requirement B3 does not extend to prevention of smoke within or from the protected shafts. Dr. Lane was clear that the dampers were required to be smoke dampers. The second way the consequences of the fire was exacerbated is perhaps one of the most important lessons Grenfell teaches us, namely the failure, principally by Exova and Studio E, to ensure adequate means of escape for disabled people. Exova and Studio E failed to ensure that Grenfell was designed in accordance with the principles of inclusive design, contrary to ADB. Exova's witnesses were strident that ADB did not require means of escape for disabled people in general needs residential buildings. As a result, Exova's fire safety strategy was silent on means of escape for disabled people, and worse, repeated the misdescription of the lifts as firefighting lifts, despite Exova having been told by Mr. Soons that they were not. Dr. Lane was clear that ADB required means of escape for disabled people, and that the description of the so-called evacuation lift in Stokes's FRAs should have prompted Exova to consider means of escape for disabled people. Instead, Exova simply assumed disabled people would evacuate, or at worst, wait in the stairwell until the fire has been put out. It is troubling that an allegedly world-class fire engineer in the 21st century could consider such an approach acceptable, given it involved an abdication of Exova's duty as fire safety engineer to ensure people's safety in fire. This is a classic example of an industry professional blaming the regulator for something which was not a weakness in the regulation, but the professional's own ignorance or willfulness. Studio E was aware of the inclusive design requirement and the presence of disabled people in Grenfell, hence Soon's commissioning Bonnet Associates to consider access in Stage E. The resultant accessible design guidance was, however, silent on egress, contrary to ADB. Studio E simply assumed the vulnerable would take refuge in flats on the same floor, but without verifying that assumption. This failure is made worse by Soons's awareness that the lifts were not firefighting lifts. He claimed he may have been confused about this, in that he knew it was not a firefighting shaft, but that alone should have caused him to ascertain whether the lifts were firefighting lifts. Means of escape for disabled people would have been uppermost in Exova and Studio E's minds, as prior to Grenfell, Exova provided for disabled evacuation in its fire safety strategy for the neighbouring Kensington Leisure Centre. Exova and Studio E's failure at Grenfell was exacerbated by the failure of others. RBKC had been a trailblazer for accessible housing and had received advice in 2010 and 2012 that those with disabilities being housed on the ground floor or a refusal to house them was a failure to comply with ADB. RBKC was also aware that those with disabilities might take up to 4 times longer to evacuate, yet it did not ensure Grenfell, its flagship renovation project, provided adequate means of escape for disabled people. TMO also failed, despite being acutely aware of those with disabilities in Grenfell, to ensure the refurbishment provided adequate means of escape, and made things worse by knowingly misdescribing the lifts as firefighting or evacuation lifts. Stokes, the fire risk assessor, also furthered the dangerous impression that the lifts were firefighting lifts and stated Grenfell had reasonable arrangements for the evacuation of disabled people. He fell below the standards Lane considered were required of him. Finally, government also bears responsibility for the failure to ensure means of escape for disabled people were fully explained in ADB. Undoubtedly, ADB required inclusive design, but as explained in our Module 6 submissions, government had been aware from 2004 that means of escape guidance was inadequate, and from 2015 at latest that the guidance was widely regarded as insufficient. To conclude, those we consider primarily at fault for the disaster had, or ought to have had, specialist knowledge and were in a position to alter the outcome by deploying that knowledge in the interests of safety. One of the inquiry's most important tasks is to bring about a sea change, which instills, both within government and across the sector, the importance of fire safety burden that they bear. This requires an appreciation that the built environment poses a danger to end users, not only to workmen working within it, a risk which has largely been cured by the CDM regulations. If the inquiry can affect this sea change, it will be a turning point in the industry's long history. Those are my submissions.
Thank you very much. I understand we're going to hear also from Mr. Friedman. Is that right? Yes, Mr. Friedman. You come up when you're ready.
While Grenfell Tower still burned, this inquiry was established. The urgency reflected the scale of the disaster, still one of the most fatal known cladding fires anywhere in the world. Since then, the inquiry has revealed an industry of manufacturers, architects and contractors who were allowed into Grenfell Tower by the council owner and its agent. You will be in a position to describe wrongs done in relation to design, materials, engineering and management. You will have the detail of the instability of the various regulatory regimes which state actors tolerated and corporate actors capitalised upon. You will now know just how out of its depth emergency response to catastrophic events was and still would be in the major cities of this country, particularly firefighting, but more generally disaster management. And you will have come into contact with people and the community, the social high-rise building and its surrounding area. Their disaster began with how they were treated by RBKC and the TMO before the fire, and continued through to an aftermath where they were left to build their lives back up from nothing. Grenfell's victims and some of its perpetrators come from all over the world, but this disaster was made in Britain. Without detracting from what you have just heard as to where discrete responsibility lies, it is important to ask, what is it about modern Britain that allowed the grave wrongs of industry to take root, for the emergency response to crash, and for its socially housed population to be treated as objects and problems, rather than people with rights worthy of respect? One of the few places in British society where those types of social contact questions can be rightly asked and legitimately answered is a public inquiry. Inquiries are commissioned by government, but they are for the public. They are not trials or ordinary legal processes. The panel properly investigates policy, governance, economics in a manner beyond the means and purpose of ordinary courts. Unlike civil and criminal proceedings, an inquiry can adopt flexible standards of proof, paper and oral analysis, and engage in fact-finding that does not only arise from direct causation of events, but identifies context, contributing factors, and broader matters of system and culture. An inquiry cannot make determinations of civil or criminal liability, yet it can pave the way for both. You have heard the BSR's call for justice. One part of that justice is in this process of publicly accountable learning. In an inquiry concerning mass fatality and complex technical investigation, it would be wrong ever to lose sight of those who died. So too would it be wrong to ask the bereaved to undergo yet further proceedings after the conclusion of your work to obtain findings about the deaths of their loved ones. That is why the inquiry agreed at its outset to do its best to establish who, when, where and how each individual died, and to place those facts in the context of the causation and circumstances of the fire. The reporting of the Module 8 presentations and their cross-reference to the inquiry's findings in the other Phase 2 modules will be the final part of that endeavour. The inquiry has also invited submissions on recommendations. Where the nature of a potential recommendation justifies it, there should be further expert opinion and a public hearing to ensure transparent ventilation of the issues. The panel does not need me to tell it that robustly testing and explaining inquiry recommendations is key to their success, but it goes beyond that. Inquiries function to correct features of governments that cannot necessarily be trusted to correct themselves. It is an important part of the inquiry's remit to draw out vested interests and opposition to essential change and to publicly dismiss unwarranted objections. The alternative is that such objections only surface later, behind closed doors and within corridors of power. It is a root cause of this disaster that its subject matter, from construction to residents' rights, has never evolved on an open, equal and accountable playing field. To regain trust, things must be different now. When one hears of the reckless and at times predatory behaviour of those responsible for the fire and its spread, it inevitably begs the wider question, what type of society allowed this to happen? On this, we offer 7 observations. First, we live in a particular type of post-industrial risk society in which advances in science and technology, with all their possibilities, also generate threats. This paradoxical dynamic of modernisation is aggravated by globalised processes that expose us to materials made and tested in one country, sourced in another, lawyered in a third, and then installed in and onto buildings by multiple contractors. Second, when we fail to properly consider low statistical risk events with foreseeably devastating consequences, we particularly expose ourselves to disaster. As Professor Terrero put it, foreseeable risk must always be multiplied by the enormity of consequence, especially so when the chance of the event happening was actually increasing, as it was with cladding fires. The LGA guide statistics on the low number of evacuations from high-rise blocks is the inquiry's now well-known example of a false counsel of security. It took no account of severity, overlooked near misses, assumed no underreporting, and left out local and international knowledge on the very danger it offered assurance against. Third, in disaster risk analysis, complacency about what is normal and abnormal is inherently problematic, and the misdirection and miseducation of the LFB is a case in point. At a normal incident, almost every one of the failings in LFB's competency at Grenfell Tower would not have mattered. Standard compartment firefighting with little incident command or communication would have sufficed. What events like Grenfell show is that a risk-related service that knows only the bounds of past or frequent experience will be fragile in the face of what is unexpected and new. This predisposition to normalcy undid the LFB on the night of the fire, but it is no doubt something that affected other bodies studied by this inquiry across its modules. Fourth, fundamental weaknesses in the relevant regulatory regimes were not acted upon as they should have been. Other submissions have dealt with building regulations, building control, and the circumvention of testing and certification. To that, we add that fire safety enforcement and emergency response lagged far behind in their understanding and capacity to respond to contemporary building challenges, and were not even close to being up to the job of deterring, detecting, and punishing non-compliance. You have seen that competency was compromised by the inferior status of fire engineering in general as an academic and vocational discipline. Within LFB, organisational culture manifested in a way where there was a particular disconnect between the fire safety department and station-based or operational firefighting. The resulting instability in the regime of itself should have caused government to identify the risk of high-rise residential fire as an issue of national resilience. Instead, civil servants and the local fire services managers held an unwarranted belief that the notorious cladding fires in locations like Dubai were not going to happen here. Our fifth point concerns localism and deregulation. The political imperative to devolve power and responsibility from a centralised state in order to unencumber public services and businesses from regulatory restrictions is not new. However, the post-2010 politics of the coalition government produced a civil service mindset that was deeply resistant to progressive reform and overly beholden to the private sector. Aside from the unreconstructed fate of the building regulations, there were other damaging consequences. For example, the machinery of central government dedicated to fire safety was comprehensively scaled back in terms of its civil service expertise, oversight and leadership. Local fire services lacked external scrutiny and challenge. Recommendations to review fire safety and operations, most significantly after the Lacknell House fire, were not implemented even following undertakings to do so. National high-rise firefighting policy, via the revised GRA 3.2, was chaotic in its drafting, irresponsibly devolved to the local fire services, and constitutes a further series of missed opportunities. 1, to acknowledge the risk posed by cladding fires. 2, to query the inflexible reliance on stay put. And 3, to review the manifest dangers posed by the do-nothing advice in the LGA guide on the issue of evacuation of vulnerable persons. All these risks were foreshadowed, none of them were addressed. 6, the inquiry has learned of a host of public sector services in decline, including the privatisation of the management of local authority housing and the degraded function of its building control. The long-term cause lies in political decisions to roll back state services and various iterations of free market economics. Again, neither began in 2010, but both were accelerated as part of austerity politics following the global financial crash in 2008. And Barwise KC, it is fair to say, aligned itself with both that politics and its economics. However, the causes of decline can also be found in the shortcomings of organisational life. The inquiry study of the LFB shows a 20th century service that is structurally and culturally ill-suited to 21st century challenges. There are basic deficiencies in management competence. Necessary reforms that have been repeatedly and cyclically identified in reports spanning 30 years have been institutionally resisted. Training, when done, replicates past practice and ignores advances in fire science, clinical psychology, and genuine integration of the control room into an incident response. There is over-politicisation of service issues with a management union divide that obscures the traditional monoculture of the service and its outdated methods. A more mundane function of localism is that political responsibility for the lack of reform is pinned on local authorities and chief officers. As a result of no formal inspection for more than a decade, this state of affairs was left unacknowledged and unchallenged, until responsibility for fire and rescue services moved back to the Home Office in 2016. Successive governments regarded themselves as positively virtuous in not intervening. Our seventh point is that the UK has no disaster management system. The regime under the Civil Contingency Act 2004 wages preparedness for disaster on the postcode lottery of the approach of any given local authority. That regime collapsed at Grenfell when the fire and aftermath were in one place. RBKC was both overwhelmed and fundamentally compromised by its long disengagement from affected communities and its obvious conflict of interest as the owner of the building. The necessary integration between central, regional and local government and other statutory responders floundered for 3 days while the council carried on, unwilling to admit its incompetence and lack of authority. In the absence of an external inspectorate system for emergency planning, RBK's weaknesses were unknown. The London regional system was labyrinthine, overly horizontal and duplicating, but most importantly, had no power to intervene in RBKC without invitation to do so. As to central government, the best description remains that of Professor Clive Walker, that it is a ghost in the machine. Under Part 1 of the legislation dealing with local emergency, the government does too little. Under Part 2, which has never been used, it takes over. Between those two extremes, there are neither sufficient powers nor duties to scale up when the nature of the local crisis requires, as it did so much here. Failure to prepare for disaster matters, not least because when disaster strikes, it invariably impacts hardest on those least able to cope. Failing to prepare, therefore, becomes a denial of equal protection. That is why we have often pressed for the panel to inquire beyond the essential immediate technical causes and circumstances of the fire. What this inquiry has ended up learning goes to the most fundamental questions a society must ask itself. The common feature of the evidence, cutting through all modules, is how little the fate of ordinary people mattered when key decisions were taken. People either did not factor in the equation at all, or they were objects without agency, statistics, profit, beneficiaries, the crowd. What happened to DSBSR was born of a failure of human accounting, a point that counsel to the inquiry felt bound to express at the conclusion of Module 8. We say that it does not have to be this way. Firstly, beyond left and right politics, it is essential to bring the concept of the state out of its long ideological eclipse and ask anew, how can it act as a source of common good? The timeline for the eclipse is generally regarded as beginning in the 1980s. Subsequent Conservative and Labour administrations limited the role of government, in contrast to the era after 1945, when it played a more significant part in welfare and planning. We are still in the era of the rolled-back state, and Grenfell is one of its greatest failings. The centre of government, particularly the ministries of everyday life like housing, fire and building, has been hollowed out, with the numbers of civil servants reduced, ministerial responsibility diminished, and decisions between subject matter experts shed. With all these diminutions, the capacity to act, to prevent and respond to a disaster of this nature was lost. Inevitably, market forces and malpractices have filled the gap. That is the paradox of the free market. When the state leaves a governance vacuum, other powerful organisations and actors will seek to take advantage, and usually for their own benefit, rather than the public good. A second defining feature of the relationship between state and society since the 1980s has been to increasingly disconnect economics from collective morality. The disconnection is pertinent to the times when relevant Grenfell decision-makers resorted to commercial cost analysis without properly including in the balance the value of human life and safety. The inquiry will have in mind, 1, Laura Johnson's decision in March 2017 to have no door-closer inspection regime at all, rather than taking emergency action to alleviate a known long-term estate-wide fire safety danger. The TMO stood by, the LFB let the matter go. 2, Colin Todd and the commissioners of the LGA Guide's justification for doing nothing to meet the fire safety needs of vulnerable persons was made on the basis of common practice of trade without considering its moral and legal implications. 3, civil servants and ministers allowed the timescales for review of a approved document B to repeatedly slip over years, despite knowledge of its flaws, with Brian Martin conceding that what government was trying to do was to balance cost of regulation with its benefits so that industry was freer to improve the economy. Even if improvement, in his sense, was at the price of weakened fire safety standards. All these decisions reflect a prevalent, learned, bureaucratic ethos and culture that prioritised what things cost in the most economic, narrow sense to the exclusion of what they were worth. Economics needs to be reclaimed as a dialogue about moral as well as financial well-being. The instances of actual engagement with residents before, during and after Grenfell is a chronicle of disempowerment. Before the fire, they were subject to institutional bias and prejudice. The attitude of RBKC, the TMO and their contractors was that people should be thankful for what they got or be ignored, even targeted or maligned. This was a relationship of master-servant that has no place in a modern democratic society. Critical to the ill treatment was that important information relevant to resident safety was deliberately kept from them, and collectively they were repeatedly denied a voice. Then during the fire, without any foundation in research, experience or training, the possibility that neighbours might act in a rational and collaborative manner when escaping from the building they knew was discounted. After the fire, when local government collapsed, the displaced community reconstituted itself in the surrounding streets, but not before different levels of government saw the situation primarily as a threat to public order. The primary motive of civil contingency response in those first 7 days of aftermath was security and containment, not compassion for human welfare. Responsibility for risk-based decisions such as these will often have a technical dimension dependent on expertise and the judgment of appointed officials, delegated contractors, and elected representatives. That cannot mean that people who bear the consequence can be excluded or disregarded. Utilising the insight and experience of those affected by decisions is always in the service of better outcomes and makes obvious good sense and shows due humility. But it goes beyond that. Without diluting legal duties, effective engagement with residents is essential to demonstrating respect for them as equals, even if respective roles differ. None of us would accept otherwise for ourselves or our loved ones. Why should BSR have been different? We say much of the answer to that lies in social inequality. The fire disproportionately killed people with disabilities, those of Middle East, African and other migrant background, and those living in social housing. The high number of deaths amongst disabled residents at Grenfell is a landmark fact of this disaster, but it is yet to be acted on. The LGA guide, which not just permitted but positively encouraged those with fire obligations to do nothing to plan or provide for the escape of such persons, is unchanged. On the eve of the 5th anniversary of the fire, the Home Office pivoted from implementation of the inquiry's Phase 1 recommendations on personal emergency evacuation plans that had been supported by an overwhelming proportion of consultees to its current ill-conceived proposals. Shockingly, the government would not only disregard the lessons of the fire, but would water down existing protections. The proposals do not apply to stay-put buildings at all. They would not impose any legal duty on responsible persons to put in place an evacuation plan. They are inexplicably limited to persons with mobility impairments, and they would place primary responsibility for enabling escape on the fire services, contrary to both long-standing principle and all the inquiry evidence of FRS incapacity and incapability, at least at present time. That leads to our emphatic plea. The inquiry must issue an urgent interim report to leave the government in no doubt as to why the intransigent do-nothing status quo is dangerous and in violation of current law under the RRO and applicable human rights. This inquiry, combining legal authority, evidential wisdom, and objectivity, is uniquely placed to incontrovertibly say this. Waiting until the publication of your final report is too late. The national, ethnic, and cultural backgrounds of those who died at Grenfell Tower has in itself always called for further reflection on the issue of race. Despite the diversity of London, the evidence heard across the modules has been of an absence of engagement with the implications of race or religion by relevant public authorities, whether in terms of linguistic, cultural, or other implications. At best, this shows an unhealthy lack of curiosity about the needs and experience of an important body of service users, but it needs to be seen as part of a broader syndrome. The fact is that every inquiry module has revealed serial ignorance and non-compliance with the public sector equality duty by all relevant public bodies, across all relevant protected characteristics, even where the issues cried out for attention to the statutory or equality objectives. The important purpose of the duty traced back to the Stephen Lawrence inquiry report and the problem of institutional, in that case race, discrimination within the public sector, meaning disadvantage caused by unwitting prejudice, ignorance, thoughtlessness, and stereotyping. It is important for this inquiry to robustly reaffirm the value of the public sector equality duty in the context of this mass disaster and to consider recommendations directed to its future effective embedding, assurance, and enforcement. Beyond this, the socio-economic duty in Section 1 of the Equality Act, in force in Scotland and Wales, but not yet in England, offers an obviously pertinent and promising legal tool to combat the institutional socio-economic discrimination experienced by Grenfell residents and those living in social housing. We urge the inquiry to say as much. Can we conclude by asking what effective change looks like? This disaster is about the failure of the duty of care in its broadest sense, legal, political, and social. The question of who is my neighbour, posed nearly a century ago by Lord Atkin in the case of Donoghue and Stevenson, and what this should mean in terms of legal duties and social values, calls for re-evaluation and evolution in our modern risk society. The legacy of Grenfell must be to intensify duties between state, organisations and people. In the main areas of building and fire safety, the duty of care will require legislative reform, tougher regulations, new offences, higher penalties. However, well-designed laws are not enough. They cannot work without sufficiently competent and properly resourced enforcement, which will not exist in Britain without a fundamental change in education and accreditation across a range of disciplines. Law and policy can quickly become out of date due to design innovation or cynical circumvention. Laws can always be amended so as to stall or roll back protections, perhaps especially so in areas of risk lying outside the public gaze, where the lessons of the past are most liable to be sidelined or forgotten. And so safeguards must be embedded into organisations and systems to enable us to trust them more. On this, we highlight three. First, the statutory duty of candour could serve as an essential constitutional innovation, provided it applies to public authorities and private bodies contracted to do public works, as well as those whose products or services have implications for the health and safety of the public. Even then, many of the organisations studied by this inquiry are not self-accountable, and therefore would find it difficult to be truly candid and frank without significant changes in organisational culture and ethics. Second, a national oversight mechanism, as long advocated by the organisation Inquest, would serve to break the current lamentable pattern of unlearnt lessons and repeated failure to act on recommendations to prevent future deaths, which includes, of course, the promptly lost lessons of Lucknow House. And third, the relationship between bureaucrats, experts, technicians, and those they serve requires a reset so that people affected by risk-based decisions, who in some cases must live or die with the consequences, are duly informed, engaged with, and listened to. But legal innovations are doomed to fail absent wider societal transformation of existing ways of doing things. Grenfell was a human rights disaster, a systematic failure of state and private actors to protect the life, security, and dignity of people. There were undoubted individual wrongdoers in this tragedy, but there was also wider institutional and societal indifference that allowed them to act with impunity. What happened at Grenfell Tower demonstrates an essential problem with the way the golden rule of faith and ethics is applied, that we don't necessarily do unto others as we'd have them do unto us when we do not or cannot conceive of being in their position. We do not imagine that their home could be our home. We do not appreciate the imbalances they endure. We do not live by the premise that in all of life's profit and loss, we are ultimately neighbours. The evidence painstakingly assembled and heard by this inquiry tells us that we must.
Thank you very much, Mr. Friedman. The next closing statement is going to be made by Mr. Michael Mansfield, King's Counsel, on behalf of, again, the bereaved survivors and residents whom he represents. Yes, Mr. Mansfield.
Good morning. Chair Faria Estefan Ali Akbar. In a sense, I'm going to close the file. And I'm going to speak, as it were, hopefully from both the heart and the mind. Because I'm treading a rather treacherous path here. I don't want to repeat any of the very fine words that have already been spoken, which we endorse as Team 2. I don't want to repeat matters that you've read in our written submissions on this as well, as they're detailed as you've seen. But I want to, as it were, touch on the themes that are already emerging. Stephanie Barwise talked about, in a sense, both speakers talked about the necessity for a sea change in approach. A society which we don't live in at the moment, and in fact is at risk of deteriorating even further. So behind all of this, the theme that I want to start with is by just a flashback of time. It's easy to forget, because the question I'm going to ask is, I hope there isn't another one, another inquiry following another disaster in 50 years' time, where all the same points are being made. Because the assiduous manner in which you have approached all of this and the patience that you have shown over the many weeks, months, and years now will go to waste unless there is a commitment. Because whether it's called a human rights disaster or characterized in other ways, what happened was criminal in the colloquial sense and in the legal sense. And this inquiry has begun, obviously, the process of achieving some kind of justice, but it's only the beginning. And what I wanted to do is to just flash back for a moment as to why the significance of what you're about to embark on. You may have thought that you've almost got there, but in fact, there is a further stage which I want to propose. In 1973, there was another disaster. It's forgotten. We certainly do need a national disaster plan. We need a resource. We need a mental capacity that remembers, lest history repeat itself, those who don't learn those lessons. It wasn't a high-rise. Maybe that's why it isn't thought about. It wasn't on the mainland in the sense it was in the Isle of Man. A large number of people died and were injured. But the points that have been made this morning to you, a large number of them were all made then. In another inquiry by another High Court judge, the Cantley inquiry. It didn't take as long as this one, but that's not the point. The point was that they touched on the very same issues that are now being touched upon. Issues to do with compliance. Because the three components that were put up on the facade of that building, in a sense a high-rise entertainment centre, a prestigious project, no doubt. None of the three complied, interestingly, with legislation in the Isle of Man which proscribed the use of combustibles. So question arose then, as it does now, how did they get around that law? How was it permitted to happen then that there should be, as it were, cladding? And the cladding burnt very fast, and don't anybody say, it's not the same cladding, but that's not the point. That's what the academics try and say. Oh, well, there's a distinction. It wasn't high-rise, it wasn't quite the same cladding, but it was the same result. Because there was an unwillingness then. It's developed since that time. But that wasn't the only issue. Because the other issues discussed in the same breath almost were to do with evacuation, which is why a large number, not because of it wasn't a single staircase point, it was a way in which there was open plan and there were too many people to get out and there weren't enough people who knew how to operate the evacuation procedures. Nobody had been trained to do it. So the similar sorts of points are coming up, including sprinklers, suppressants, including fire extinguishers. They had them, but they didn't have enough trained people to use them. Now, these may seem, in a sense, of course, because it's a long time ago, but I raise them because unless there is the sea change that is being talked about, there will be another inquiry following another disaster of this kind. And we are going to phrase it slightly differently. That what one's looking for here as a result of what kind of society and the sea change, I think you yourself used the term during the hearing, we're looking for a change in the mindset, a change in the culture that has pervaded many, many years since 1973. And that mindset is one in which there are forces at work you've heard about. They are political forces. I began the opening in phase one by reference to the red tape initiative, which was meeting on the very morning of the fire. Meeting in order to see if it was possible to dissemble regulations. So a very strong political stream of thought set against, obviously, a much longer period of deregulation. So political forces are at work in this particular field. Economic forces, of which you've seen, cost-benefit, or the pyre of profit, if I can put it that way as well. So they're the economic forces that are at work. But there are the social forces as well, also at work, which you've heard described this morning. The social forces which are concerned with race, with class, with social housing. All of those merge together to form another force that ensures that the mindset that we need to change, what do we need to change it to? It needs to be changed. I'm going to put it into one proposition. It's one that is the theme of our submissions throughout phase 1 and phase 2. And that is fire safety first. It's a simple thought and a simple proposition. But, as Mr. Friedman was just saying, nothing's going to change unless there is a change in values, unless there's a change in mental approach to these matters. How do you affect change? And we say, sir, you're in and your colleagues are in a really extraordinarily powerful position to affect change. Can I just interpose at this point how that might happen? And I fear it may be that you have already considered this. Please forgive me if you have. But it's been hinted at this morning. But I'd like to just develop it a little more. Developing it a little more means that, of course, it's not for us to say when your final report will be, but we anticipate it certainly won't be this year, and sometime late next year, possibly earlier than that. And the enormity of the task is appreciated by all the families, many of which are here today. And they appreciate the efforts that have gone in already, and they're not, as it were, unappreciative at all. But if the effects of what you have been doing for these years is going to be felt, then you have an opportunity to ensure that effect yourselves. The suggestion we make for your consideration is that over the ensuing months, at some point, you issue an interim report that's been mentioned this morning. It could be a series of interim reports in order that nobody is confused about what is intended. Within those reports, you specify recommendations that we know clearly you will make, constructive, far-reaching recommendations, which you did after phase 1, or at the point of phase 1. One of which, of course, hasn't been implemented, an important one, already mentioned, a serious violation of human rights, the Human Rights Act, the Equality Act, Section 2 and Section 14 read together, almost ignored. Ignored on the basis, and I just again interpose this, the Minister for Fire Safety, House of Lords, spring of this year, an unimaginable, I hope this is not, as it were, an exaggeration, or as it were, placing too much on a few words, but it wasn't just, it's not practical, it's not proportionate, it's not reasonable. He actually used the simile that, well, the disabled might get in the way of the able-bodied getting out of the building. He didn't use those words, but that was what he was saying. That, if anything, demonstrates the depths to which our public life has descended. Never mind the Nolan principles, which we've emphasized several times, of which there are 7, one of which being the duty of candor, which should be embraced, we say, as it shouldn't have to be. Why should we have to be thinking about legislation to try and set the agenda of candour. But that's, in a sense, where you and your colleagues come in, because in an interim report or a series of interim reports in which you specify particularly important recommendations, it's not being suggested, for example, that you would take time on what you regard as perhaps minor recommendations, but major recommendations which will, we hope, have an impact on the approach of industry, on the approach of local government, on the approach of central government. And the approach of central government, although there have been some concessions in that field, perhaps I don't need to do more than mention one name: Lord Pickles. I don't need to spell out what he said and how badly he got it wrong. Not misspeak, Lord Pickles. It's indicative of a frame of mind. Now, in those, as it were, attempts that I hope you might consider making, you have the power under the Inquiries Act, so it's entirely within the framework, and again, I don't need to spell that out. You have a highly competent team of lawyers and advisors, and anyway, you probably know, but sections 24 and 21 allow you to, as it were, issue the report, but you can also say, we'd like answers. The importance of that is to find out publicly to what extent this is not going to be a report that is left to languish on a dusty shelf, although no doubt digital these days. Because that's almost what happened with the Isle of Man, but I'll come back to what's happened on other occasions since then. That's not the only one by a long way. Now, this scheme that I'm suggesting that you might consider involves the issue of the report and for a response. You can monitor the response, if you wish, by suggesting to the recipients, we'd like to know within 28 days, a familiar phrase, I've no doubt, to many departments. Whether they can stick to that's another matter. And they have a choice. They can either not respond, which will be made public, or they can respond saying why they accept the recommendations and what they're going to do about it, or they can say, well, we don't accept them and these are the reasons, and then you can have, if you wish, I know this must sound daunting, this must sound forbidding, you can have a further hearing in relation to that with expert advice, as already has been hinted at, in relation to that. This is extremely important for public confidence, because one of the aspects of a public inquiry is the regeneration of public confidence in the system, because no one can say anything other than Grenfell Tower is the epitome of a complete collapse of a system. Not just a construction system, but a system of governance, which hasn't got the principles which I've already alluded to, namely the Nolan principles. Now, I'm saying all this not without precedent, because 3 other inquiries at the moment have inaugurated. It's not exactly the same. They each do it slightly differently, and obviously be a matter for your discretion whether you even do it at all. But the infected blood inquiry are doing it, as well as the Manchester Arena, which was only part of it, was a report issued just before the weekend. So these inquiries are doing it, and most of all the child abuse inquiry. And they're setting a time frame within which they require answers in writing and then hearings, no doubt, at some stage in public. And we say that is perhaps one of the most important. You may have thought the most important has already passed. Well, in one sense it has, because although the Grenfell Tower is still standing as we leave London on the west side, there it is as a monument, bereft of life, but the community that lived there still stands. The community that lived there require this level of involvement and participation in a further stage, as do the British public, because, as we've learned since, there have been, unfortunately, during the currency of your inquiry here, other fires where, if I just pause for a moment on a recommendation, PEEPs, obviously, we've put that top of the agenda, a priority, part of the mindset, fire safety first. PEEPs, right at the top, how anybody can, as it were, humanely reject that. But there are obviously other priorities that follow. One of them is, and I've posed this once before, if I were to go around the room here today and say, first of all, identify who lives in a high-rise, and I know there are some people in this room that do. If there's a fire in your block, what do you do? What do you do? What's the answer? You would think by now, since 1973, somebody would have thought of how to work this out. It's not, as they say often, a sort of rocket science to work this out. It has to be tailor-made. It has to be, as it were, building specific. But on the other hand, it's one of the things that the Lakanal coroner put first in her letter to Lord Pickles, well, and others. There needs to be not just national disaster of plan, of course, there needs to be guidance, this is what she was saying, on evacuation procedures. So the answer to the question is most people don't know, because there has been no national guidance. The London Fire Brigade perhaps have made strident steps towards at least a solution of a kind. Otherwise, we don't know any more than we did before. How can this be? So if, I give it as an example, you do want to make suggestions about, in the context particularly of high-rise, because obviously where ladders can't reach, where hose pipes might not get, where water pressure may not be sufficient, all the points you know about, then they need to, as it were, at this moment in time, if you make that recommendation, it needs to be, as it were, canvassed, and it needs to be properly investigated, as do other simple measures, like the suppressants I've mentioned already, namely sprinklers, fire extinguishers, but there are many others that you might want to do, and these propositions are all constructive. And I just end this part of what I'm saying, I'm looking at the clock carefully, is this, and the reason why I've taken time to emphasize this, as you may know, I've been involved in other inquiries, so have many people here, but particularly the Lawrence inquiry. Another High Court judge, familiar to you, or Justice Macpherson, very anxious he was that what he had to say, what he'd discovered over quite a long period, not as long as this, but over a course of nearly 2 years. He was anxious that they were implemented, and he kept saying this to various authorities that appeared in front of him, that the 77 recommendations that he was in the end going to make about how matters could be resolved, he didn't want them to rest on a shelf. But of course, once you've issued the report, there is no legal, and I hesitate to say as far as current governments are concerned, I suspect no moral obligation either to necessarily do any. That is why the precursor of a procedure before you issue the final report is so significant, because in Lawrence what happened was that the family, it wasn't obviously under the Inquiries Act, but the family decided, we say quite rightly, to engage in the process of ensuring implementation. In other words, they became, what Inquest has suggested, they became the national oversight body for the proposals. And what happened on a practical basis was that Mr. and Mrs. Lawrence hired the Central Hall, Westminster, once a year for a number of years, and requested, and it was a request that was met, the authorities, the government ministers, and others, and police force chiefs, to attend, and they would as it were, have a book of reckoning on account. They would ask, well, have you done these? What about this one? What about that one? Not expecting that they would all be implemented overnight, but they were expecting some kind of feedback, some kind of positivity, some kind of recognition. And that happened. It still hasn't finished, but the process was begun by them. Well, we say here, the families have said to you very clearly, on many occasions, Hanan Wahhabi said it, and others. It lives every day, they live with it. This is not a forgotten tragedy, because they've lost a home, and in many cases, some cases, the whole of a family has, in the flick of a finger, gone. Therefore, their anxiety is to ensure, for the benefit of others, that they don't have to go through this. And this process that I'm suggesting to you might, I hope, appeal to you, because I just want to, as it were, emphasize two. There are two quotations, and only two. I was going to ask for a document, but I'm not going to ask for that. But I do want to pray in aid the as it were, the thoughts of residents and occupants, and the way they have perceived long before anyone else. There was a meeting with residents later in 2017 in December, where this was said by one of the residents. I'm not going to name this particular resident, or any of the others for that matter, because they speak with one voice. And December 2017, this particular resident said, "What is clear here is that Grenfell Tower was no accident. Grenfell Tower was a catastrophic incident that should never have happened and was preventable. Grenfell Tower happened due to the serious systems failure, due to a culture of neglect." I pause for a moment. Grenfell Tower was uninhabitable for 10 years because, for example, the ventilation system was beyond economic repair. It's not just an attitude to a building, it's an attitude to occupants. And he went on to say, due to a culture of self-interest and due to the fact that residents were treated at certain times as second-class citizens, which is precisely why all the examples you've had in this inquiry are, interestingly and not coincidentally, social housing. Knowsley Heights, well, you know them, Garlick Court, and so on. I don't need to go through them. But the other matter which I wanted to, I don't ask for it to come up on screen. I know you will have heard of it before because I've read passages in Module 3. But I wanted to end on it because we hope this type of letter is never had to be written again by the Grenfell Tower Leaseholders Association in September 2010, 7 years before this fire, relating to the conditions in Grenfell Tower. It begins, the passage, it's on the 5th page. "We are very shocked to learn from you," that is the Royal Borough of Kensington and Chelsea, TMO, under the heading fire. It's a very long letter, very considered letter, health and safety. "We're very shocked to learn that you considered the defect in the building exposed by the fire as a minor fault, when it had potentially fatal consequences." It wasn't a cladding fire. That doesn't really matter. What matters here, as we know, is the toxic fumes which can be traced back to the cladding and the installation. Both have contributed to that. And he goes on to say, they go on to say, they consider it a major fault. But when describing the conditions of evacuation, the effect and impact of smoke, because that's the cause of death in most of these cases, in all of these cases, it may be difficult without the pathological evidence to go further than it's commensurate or consistent with exposure to fire. However, we would say there's a very obvious inference that can be further than that. It's toxic, acrid black smoke. The staircases of the surrounding high-rise buildings are exposed to open air and natural light, and so, in case of a fire, the smoke can easily escape. But Grenfell Tower, with its interior staircase, malfunctioning ventilation system, there is certainly a high probability that in the event of another fire, the whole building can become an inferno. 1973, 2010, when is somebody going to sit up and make the connections? And that is not happening because of the forces I mentioned at the beginning, the political and economic forces that have to be countered. And we would ask, sir, that this is the opportunity beyond measure that you have, and the families want to join with you in order to do that part of the suggestion that I've made. And I haven't been through all the other matters where there's been demonstrable failure and deplorable characteristics of arrogance, complacency, lies, deceit, all the way through. Whenever I mention those words, I'm sure particular witnesses will be conjured up in your minds as to, as it were, representing those. We say this inquiry should end, we hope, on a positive note in which the families can stand alongside their tower and say they've achieved something for later generations. Thank you.
Well, thank you very much, Mr. Mansfield. Well, at that point, we'll take the break for the morning. We'll rise and we'll all resume, please, at 11:45. Thank you very much. Now, next we're going to hear from Mr. Adrian Williamson, King's Counsel, on behalf of his group of BSRs. Yes, Mr. Williamson.
Thank you, sir, and members of the panel. It's now more than 5 years since the fire and more than 4 years since Mr. Millett said this on the first day of phase 1 of the inquiry. The fundamental question, he said, which lies at the heart of our work is how in London in 2017 a domestic fire developed so quickly and so catastrophically that an entire high-rise block was engulfed, and how it was that 71 people lost their lives in a matter of hours, leaving hundreds without a home and for an inheritance, an abiding sense of injustice, betrayal and marginalisation, leading to an overwhelming question, why? Although we should now sadly substitute 72 for 71 in that quotation, Mr. Millett's question and the topics which he raised remain at the heart of this inquiry. Following the publication of the Phase 1 report, the inquiry reconvened in the January of 2020, and on the first day of that hearing, Mr. Millett reminded all concerned that he had invited, he said, the core participants not to engage in a merry-go-round of buck passing. But, he said, with limited exceptions, that invitation had not been accepted, and instead their case remained was that everything was someone else's fault. As Ms. Barwise has explained this morning, that largely remains the case. Now, in this short presentation, I'm going to discuss a number of aspects of the evidence which shed light upon the question why asked by Mr. Millett. But before doing so, I would like to make some general observations about the evidence you have heard, in particular the expert evidence. So far as that expert evidence is concerned, we, Team 2, have in general been impressed by the commitment shown by the inquiry's experts and by the high quality of the work they have produced. However, the inquiry should be careful not to follow, we would say, too unquestioningly, the lead given by its experts, however distinguished. In the end, it is for the panel and not the experts to answer Mr. Millett's question. A good example of that is the testimony given by Professors Torero and Bisbee as to the experiments carried out in Edinburgh, which formed work packages 1 and 2. The important overall conclusion of this exercise was that it was the ACM and not the insulation products which was the primary cause of the fire. A conclusion, I think, largely adopted by Ms. Barwise this morning. By contrast, we would submit that an appropriate finding is that whilst the Rainabond PE was primarily responsible for the rate and extent of fire spread during what has been referred to as, quotes, vertical fire spread up, close quotes, both the ACM and the insulation contributed to the fire, and it is impossible to say the exact proportions in which they did so. We would say there are important reasons why the inquiry should proceed with caution in relation to the experiments and the conclusions to be drawn from them. First, the experiments were conducted by the inquiry experts alone, and the core participants and their experts had no input into devising them or analysing the results. That is not to criticise the professors or the inquiry. Such a procedure was no doubt unavoidable given the circumstances, particularly the pandemic. However, such a unilateral approach is clearly far from ideal and would not be acceptable in litigation. Secondly, and associated with that first point, it is the case that the inquiry has not heard the views of other experts either upon the experiments or in relation to the causation issues generally. Again, that would not be acceptable in litigation, nor have the inquiry's own experts been subjected to searching cross-examination as they would be in High Court proceedings. Thirdly, the experiments carried out are innovative and indeed untried. The design and specifications of the experiments have not been shared as yet with the wider fire expert community. Before other experts could accept the validity of the tests, there would need to be more experimentation to understand what Professor Bisbee himself describes as, quotes, the immense complexity of the heat transfer environment with a ventilated rain screen cladding cavity, close quotes. Fourthly, the experimental results obtained are limited to the experimental apparatus build size of about 1 metre. Given the small-scale nature of the experiments in Work Package 2 and the absence of a whole system test, it is submitted that only limited conclusions can reasonably be drawn regarding the contribution of the insulation to the spread and intensity of the Grenfell Tower fire. We would also suggest that this inquiry needs to sup with a very long spoon when considering submissions from Kingspan and others to the effect that the insulation ultimately played no part in the fire. After all, Professor Bisbee has concluded that the ease of ignition of K15 and of RS 5000 might well be relevant to the initial growth of the fire outside flat 16, as well as the absence of foil faces on combustible insulation around windows. I turn now to deal with some of the substantive issues. In these brief oral submissions, I am not aiming to, and in any event cannot, repeat the many matters which have been covered in the vast amount of oral and documentary evidence you have received. Rather, I want to use this opportunity to seek to bring together some of the larger themes. Fundamentally, we would submit the question why and the so-called merry-go-round of buck passing are two sides of the same coin. A fundamentally fragmented and inadequate construction industry, a dysfunctional marketplace, and an unfit testing and regulatory system combined to lead inexorably to this terrible fire. The story begins with the evidence we heard in Module 1. The very structure of the construction industry was one of buck passing, and the buck was being passed between incompetents. The cost-cutting that has characterised procurement in the construction industry for the last 40 years, especially in the public sector, was to lead inexorably to the events of June 2017. Indeed, the evidence led in Module 1 showed that the key players in the refurbishment, Studio E, Ryden, Harley, Exova, were grossly negligent and wholly ignorant of the fundamentals of what they were supposed to be doing. Their organisation, both individually and collectively, was woefully inadequate. The main aim of each individual organisation was to get the buck off their desk and onto someone else's. As Professor Torero explained in Module 7, what was needed was, quotes, a very competent professional, a professional that has some level of understanding and is interacting in an effective manner with professionals in other disciplines, close quotes. In fact, there was a tragic mismatch between a system, or rather a failed system, which could only operate safely if manned by highly competent, well-coordinated professionals, and the inept, ill-prepared personnel and firms who were in fact engaged. Moreover, those to whom the residents might expect to be the guardians of the public interest, RBKC and the TMO, were equally inept. In particular, RBKC's building control officers did not know what they were doing and were in any event overwhelmed by pressures of work in a world of austerity. Indeed, the gulf between what was required to deliver a safe building and what was provided was vast. Professor Torero explained that there needed to be a complete harmonisation between fire safety strategy and building design, a feature wholly absent at Grenfell. Instead, it was apparent from the entirety of the expert evidence adduced in modules 1 and 7 that there was a chasm between the level of competence required to ensure fire safety and that actually on display. To take one example, Professor Torero was extremely damning about the quality of ex-Over's work, saying, quotes, "The people who were doing those reports lacked the requisite competence to do a proper job or chose not to do a proper job," close quotes. This was sadly not only true of ex-Over, but of almost everyone associated with every aspect of the refurbishment. The evidence given in Module 1 was shocking in that it revealed a construction industry which was wholly unfit for purpose. And this was not an isolated situation. Ryden, Harley and Co. were probably typical of many in the industry. They just happened to get caught. But what Module 2 has showed is even more horrifying. The inquiry will need to condemn the actions of the manufacturers Arconic, Celotex and Kingspan in the strongest possible terms. They were at the very least reckless in pushing dangerous products into the market. In selling those products, they were fraudulent in their sales tactics and in their dealings with those who were charged with testing and certifying the products. In their overarching submissions, Arconic seek to justify the use of ACM PE on the basis that its characteristics were well known in the industry. But those submissions fly in the face of the contemporaneous internal evidence. You'll recall Mr. Wehrle saying internally that PE was dangerous on facades and everything should be transferred to FR as a matter of urgency. You'll recall Deborah French of Arconic sending Wehrle a link to a BBC news story reporting on a fire in the UAE on an ACM facade building. Ms. French accepted in evidence that the dangers of PE cladding panels on high-rise buildings were well known, and yet she was continuing to offer PE core as standard, including in respect of Grenfell Tower. Moreover, Arconic were at pains to hide the true circumstances, the true facts relating to PE. Wehrle, for example, saying internally that this was something we have to keep as capitals very confidential, 4 exclamation marks. Nor were Celotex any better. They seek to criticise other parties to the refurbishment, but they are silent as to their own role, knowing as they did that RS 5000 would not meet BR 135 criteria on the proposed wall system, and by extrapolation, neither would a desktop study nor a fire engineering assessment. Yet they were still happy to take the sale and did so on this and many other projects. Of course, the producers should only have been selling safe products which had been thoroughly and openly tested by reputable independent bodies and which were then marketed to the construction industry in a transparent fashion. None of this happened. For example, as Professor Bisbee explained, the way Kingspan were allowed to do their testing, quotes, in order that a claim could be made that the surface of the K15 was class 0, close quotes, was utterly indefensible, quotes, both by any manufacturer and or by any compliance testing laboratory who knowingly undertook and reported such testing. Indeed, the manufacturers, rather than taking an honest and open approach, were simply trying to game the system so as to place unsafe products on the market. For example, Professor Bisbee said that Kingspan, by testing the foil facer on its own, was, quotes, just completely and utterly nonsensical and could never be defended, close quotes. Moreover, these companies are still operating openly and unrepentantly, a fact which causes particular offence to those whom we represent. Celotex claim to have cleaned up their act. Arconic do not even pretend to have done so, and Kingspan still assert that their products are safe on high-rise building. Indeed, incredibly, even after the fire, Kingspan have been lobbying government and others in seeking to show that cladding with European classification A2 could also lead to a failed BS 8414 test. This is a glaring example of the lengths to which manufacturers have gone to ensure their products continue to be marketed. For example, Kingspan set up a test using an A2 cladding panel which they suspected would cause even a robustly designed BS 8414 test to fail. They then drew that result to the attention of the Select Committee in relation to its Hackett inquiry, seeking to persuade them that the products used in the system tested would be permitted under the government's proposals to ban combustible cladding. So how could these rogue companies operate so successfully and so shamelessly? Well, the story there is that the testing and certifying bodies, the BRE, the BBA and the LABC, were at best asleep at the wheel in engaging with these manufacturers and at worst positively collusive with them in their sales tactics. On any view, they were far too close to their quotes clients, close quotes, and far too reluctant to bite the hand that fed them. As Professor Bisbee also explained, the problem was compounded because those who were charged with invigilating the likes of Kingspan were in practice conniving with their fraudulent conduct. As he said in evidence, quotes, "The issue is that somebody somewhere within this process of building regulation and oversight needs to be the person who stands up and says, no, this is not okay, we can't be doing tests like this, and that doesn't happen, and that's the issue," close quotes. In fact, the evidence given in modules 2, 6 and 7 showed clearly that the so-called system of regulation, testing and certification was not in fact a system at all. It was completely defective. The bodies charged with testing and certification were unable to provide an adequate system. Central government was at best completely indifferent to the unfolding disaster that was the supposed system. The ADB provided an inadequate code to regulate the industry, a code which the government was unable or unwilling to reform. And as Professor Bisbee said, quotes, "The system was created specifically to enable people to circumvent the rules," close quotes. In fact, the actual, quote, system, close quotes, in place put a burden upon professional competency which those operating in the field were in no position to discharge. This fault must ultimately lie with central government, for it was they alone who could devise a more appropriate regulatory framework. Indeed, as Professor Bisbee explained, the building regulations and ADB should have been much more explicit in setting out what was required of the professionals carrying out design. This problem was compounded not only by a lack of competent personnel in the industry, but also by the fact that the judgments required by the building regulations and ADB were unclear and subjective, as Professor Bisbee also explained. At the heart of all this was a government machine unable or unwilling to provide adequate guidance and supervision to a construction industry in desperate need of such direction. This despite the experience of numerous serious fires, as Mr. Mansfield has referred to. Not only was government supine, but it missed the chance to make matters better when the Garnock Court fire occurred. Instead, it chose to make matters even worse. Further, as Professor Bisbee also noted, if Knowsley had been properly analysed, quotes, "maybe we wouldn't have had many other fires, including Grenfell Tower." What is striking about the British government's handling of these issues is the startling ignorance of those supposedly in charge. lest it be suggested otherwise, this is not a case of requiring the British government to do the impossible or to consider issues which have become clear only with hindsight. On the contrary, it is apparent that other jurisdictions have managed these issues much better. See the Australian experience cited by Professor Torero as to what could and should have been achieved in Britain. The inquiry will therefore have to make sweeping criticisms of the failed system of testing and regulation, a quote system, close quotes, which has been shown to be totally deficient. This criticism should extend to the testing and certifying bodies, but it should be particularly unstinting in respect of the governmental bodies which have allowed this disastrous situation to develop. I turn then to the way in which the tower has been inspected and maintained in the years leading up to the fire. This is a sorry story of neglect and indifference, of which time allows 2 examples only. The first relates to the so-called fire risk assessments carried out in the years before the fire by Carl Stokes, as to which you heard evidence in Module 3. These were, or at least should have been, a crucial preventative measure. Both the assessment and the assessor needed to provide vital advice. The basic object was to discern what might cause a fire, how to stop it spreading, and how residents could escape. In fact, Mr. Stokes was woefully unqualified to carry out the assessments, and the FRAs to which he put his name were repeatedly wholly inadequate. Nor did the TMO have any systems in place to interrogate his work, or thereby to safeguard the interests of the residents. The second example relates to the smoke control system, as to which you have heard evidence more recently. This system, too, had a long history of neglect, non-compliance, and being inoperative. It is staggering that there is no evidence of any attempt to fire safety engineer any aspect of the primary refurbishment, not least the SVS, the smoke ventilation system, the requirements for which Exover omitted from its fire safety strategy. There was no attempt to develop an engineered fire safety design integrating other fire safety systems within the building. None of PSB, Exover or RBKC had any regard to BS 7974 or any other fire safety design framework. The objective of any extract system, as emphasised in ADB, and the fundamental purpose of the design of any mechanical SVS for the tower was to maintain tenable conditions for means of escape in the extended travel lobbies and for means of escape and firefighting in the single stairway. In fact, very little regard was had to maintaining tenable conditions at the design stage. Furthermore, in December 2013, RBKC rejected enlargement of the shafts. There was no engineering justification for this decision, which did not place safety at the heart of the project. Had there been competent construction management of the project, capital works to enlarge the shafts should have been considered at an early design stage. Similarly, had there been competent building control, this fundamental early design consideration would have been considered. Consequently, the SVS extract shaft size represented a limitation on the capacity of the system to exhaust smoke. This was the first of many abject failures. The design approach actually taken amounted to looking at the system as it presented itself, a system which was non-operational and had not been maintained for many years, and then applying the non-worsening principle, so-called, to a dilapidated system. PSB did not demonstrate compliance with either the regulations or the original performance requirement. They ought to have aimed to produce a design that complied with one or the other. In the event that was not possible, the system should have been condemned and a root and branch review of performance considered. Therefore, and in summary, the design and design delivery failed the residents in numerous important respects. The design actually adopted amounted to cherry-picking selected performance parameters, was not a recognised industry approach, and was not recommended by the relevant guidelines. Turning then to the smoke control dampers, British Standard EN 121018 of 2011 sets out the performance requirements and relevant test standard and classification standard for these dampers. Based on sections 8 and 10 of ADB 2013, the minimum performance duration of performance for the dampers protecting an escape route is EI20S. A smoke control damper tested to British Standard EN 136610 of 2011 and classified to British Standard EN 135014 of 2007 as EI20S would satisfy the requirements of ADB 2013. However, those standards were not considered at the time of the renovation project. The construction therefore allowed smoke to pass across different fire compartments. I should next, and almost finally, say something about water, yet another area where the residents were badly let down, in this instance by the LFB and Thames Water. When considering water distribution systems, the required outcome is that the flow rate at the point of use is sufficient to meet the service requirement. The advantages of testing supply are self-evident, but the LFB never did so. A lack of record information and technical knowledge, combined with communication failures and an absence of training, precluded the efficient management of the network. Thames Water do not appear to have been cognizant of the substandard discharge coefficients of the distribution valves and did not communicate that to the LFB. Of course, even if the LFB had been told, they would no doubt have been unaware of the significance of the fact due to a want of familiarity with the standards. Furthermore, Dr. Stoyanov rightly formed a highly critical view of the quality of communication between Thames Water technicians and engineers. It seems there was little communication on the night of the fire, and the quality of the communication did little to advance appropriate fire water supply to the tower when and where it was needed. I turn finally to the topic of LFB testing, rated inlet pressure and flow rate. There were gross failings here, also in technical competence. Professor Torero was rightly scathing about the LFB's operational response, saying, quotes, "The evidence shows that the real competency is so low that it leads to practices that endanger the public and LFB staff and prevents the organisation from learning." The evidence of Messrs. Torero, Johnson and Stoyanov show that the LFB has failed to engage with technical matters within their various areas of expertise. Mr. Johnson referred to poor communication as a particular issue. Professor Torero showed that the LFB were out of date and one-dimensional, capable only of fighting the fire they are presented with the equipment immediately available to them. In conclusion, and looking at this inquiry overall, you are clearly going to have to make highly critical findings about a large number of people and organisations. But this is not just a story of incompetence or worse on the part of individuals and companies. They were all operating within a culture which did not encourage either competence or honesty, a market and a system in which there was a headlong race to the bottom. And that culture had flourished because governments and regulators had not put in place adequate procedures to root out the fraudulent and the unskilled. The fire, therefore, was the result of catastrophic failures on a personal, corporate, regulatory and governmental scale, and we urge the inquiry to so find in the strongest possible terms. The bereaved survivors and residents expect the panel to so find, and they wait expectantly upon your report. They have waited patiently, but the time for waiting is now over. Thank you very much.
Thank you very much, Mr. Williamson. Next, we're going to hear a closing statement by Mr. Imran Khan, King's Counsel, on behalf of another group of bereaved survivors and residents. So take your time, but when you're ready, Mr. Khan, we shall look forward to hearing from you.
Good afternoon, panel. When we first raised the issue of closing submissions with our clients, the overwhelming view that it was going to be a complete waste of time. Not because they didn't think that you wouldn't produce recommendations. You will, in the words of the advert, probably produce the best recommendations in the world. They thought it was a complete waste of time because they didn't think and don't think that despite your recommendations, anything will change. That's a concern that they have. Because governments in the past, today's government and successive governments, are unlikely to make the change that's needed. The fact is that immediately after the fire, our clients and all those that were in Grenfell knew what happened and who was at fault. In fact, the world knew what happened and who was at fault. What they wanted, first and foremost, what they expected immediately after fire, was arrests, prosecutions, and imprisonment of those that were culpable. But instead what they got was 5 years of this inquiry, this public inquiry. But for all of its advantages, what public inquiries do is they give the appearance of change without any change. They give the appearance of difference without making any difference. And so our clients, our cohort of clients, weren't particularly interested in contributing to closing submissions. But they were persuaded, more in hope than expectation, that they should do so. And they wanted us to focus on 4 key elements, which we have done. And the submissions, the written submissions that we have submitted, I'm not going to read all of those, but it's part of it. And it starts with a plea from our clients, a desperate, impassioned plea, that this inquiry produces a set of recommendations and conclusions such that it leads to a wholesale change to the housing sector in the UK. Our clients believe that the fire will forever be remembered, we hope, in the history of this country. And depending upon what you and your colleagues, Chair, do, this inquiry and its recommendations could either be recorded in that history as a forgotten footnote to the disaster, or the one single moment in time which changed everything. The choice is yours. We have subtitled these submissions as, quote, the magic pencil, end quote. It's taken from the words of a child affected by the fire. You know the family, sir, panel. Our client's son lost his brother on the night. And when asked what he would want if granted 3 wishes, He said that one of the wishes would be for him to have a magic pencil, so that anything he drew with it would come to life. In this case, he wanted the power to draw his brother back to life. In a sense, this inquiry has that magic pencil. Not, of course, to bring the deceased back to life, but to write recommendations which have the power to ensure that lives are not lost in the future. Not just here in the UK, but elsewhere in the world. As disasters like Grenfell are not limited by borders and boundaries. You may recall the events of Sunday, 29th of August 21. A fire took hold of a tower block in Milan, which had cladding identical to that on Grenfell Tower. In that case, the absence of victims, apart from 2 pets, was considered miraculous, and down to the fact that the fire took place in the afternoon of a hot Sunday in late August, when most of the residents were not at home, as well as the fact that the fire service did not even attempt to put the fire out, but instead broke the doors down to get everyone out. If nothing else, the Milan fire shows the global nature of this problem. And this inquiry, and the UK, and this panel can be a leader in addressing it. On behalf of our clients, we do not today seek to rehearse the evidence heard. That would be impossible. It seems to our clients and us that it's self-evident to anyone who has had even a passing interest in the hearings as to what happened during the events that led up to and occurred in 2017. You and your colleagues are well aware of it, and in any event, others more skillful who've come before me have addressed you more persuasively, more eloquently than I could ever do. Our clients seek to address you in more general but equally emphatic terms in 4 discrete matters: race and social inequality, foreseeability, implementation, and apology. The first issue we address is that of institutional racism. Given the tower's history and the makeup of its residents, the fire was, we say, simply waiting to happen. We have repeatedly, sir, urged upon you to consider whether race and social background of the residents of the tower played any part in the disaster. We did that from day one in our opening submissions. That plea, unfortunately, has fallen on deaf ears and represents a failure, we say, on the part of this inquiry and a missed opportunity to change the lives of millions of people of colour in this country. The reality is that without understanding the context in which the tower came into being and why it was populated as it was, this inquiry will have failed to understand why the disaster happened and how it can be avoided. The tower's genesis is best described by the social and political theorist Ida Denowit, who wrote this, quote, "When Grenfell Tower was built in 1974, the surrounding area in Ladbroke Grove was known as one of the most degraded places in London. The harsh conditions of the piggeries in the 19th century, the slums of the 1930s, and the race riots of 1958 had earned the area a notorious reputation. Populated by the poorest of the English working class and people of Irish, Jewish, and Spanish descent, after 1948 and Empire Windrush, Ladbroke Grove also became home to the Afro-Caribbean immigrants excluded from living elsewhere, alongside a sizable Moroccan community. Grenfell quickly became known as the Moroccan Tower, a result of its large number of Moroccan immigrant residents." End quote. From the outset, we say, the tone was set and the destiny of the residents arguably determined. As Robert Booth, social affairs correspondent for The Guardian, noted in an article published in June 22, at the time of the Grenfell Tower refurbishment, quote, "Many councils had seized on property development, some to fill holes left by government cuts, others out of free market instinct and desire to boost home ownership. A prime potential redevelopment zone in Kensington and Chelsea was Grenfell Tower and its surrounding 1970s estates. This had long been the genteel borough's poorest area. In the 1930s, a Labour MP, Sir Stafford Cripps, lamented, "Of all the slums in England, those in North Kensington are the most tragic." Inside the council, the tower was assessed as one of the borough's worst property assets, a poor cousin that blights the surrounding area. From a purely financial perspective, the council viewed Grenfell as worthless. Laura Johnson, Director of Housing, wrote a memo to the effect that anything spent on Grenfell was money down the drain. It would seem a tower block filled mainly with so-called immigrant residents was viewed by the council as worthless. Social inequality in wider society is unfortunately inextricably linked to social inequality in the housing sector. If you're poor and marginalised, you will be neglected. If you're poor and marginalised, you'll be treated differently. If you're poor and marginalised, you will receive less care, receive less attention, receive less security. If you're poor and marginalised, you're more likely to die. We submit that this was and continues to be indicative of the pervasive attitudes in our society towards the residents of social housing. Had the tragedy occurred in a different community, those involved in the refurbishment would have likely taken a very different approach. As Adam Smith noted in The Theory of Moral Sentiments, this disposition to admire and almost to worship the rich and the powerful, and to despise or at least to neglect persons of poor and mean condition, though necessary both to establish and to maintain the distinction of ranks and the order of society, is the great and most universal cause of the corruption of our moral sentiments. These words were written in 1759. Some 250 years later, they still regrettably apply here. It cannot and should not be the case that in 2017, the wealth, social standing, class, or race of a person determines their future, determines whether they live or die. Yet that is, we say, precisely what happened in this case. Those who died in the fire were largely from low-income homes, with at least 85% of them from minority ethnic backgrounds. The government's race disparity audit in 2017, the year of the disaster, said that those from minority ethnic communities were the most likely groups to rent social housing. Kieran Yates, writing for The Guardian in 2020, noted that, quote, official housing surveys have found that 40% of high-rise residents in the social rented sector are from black, Asian and minority ethnic communities, which make up 14% of the population. Throughout the UK, children from minority ethnic communities are more likely to live in dilapidated and overcrowded housing than white people, and they are 75% more likely to experience housing deprivation. The connection between policy and the economic reality for most people is not one that is readily recognised by those in power. Yates's article highlighted that, quote, the disproportionate ethnic pay gap that communities of colour experience, for instance, has knock-on effects. Lower incomes mean greater reliance on state provision and more likelihood of ending up in low-quality housing. This may account for the 1 in 6 ethnic minority families in the UK who have a home with a Category 1 hazard, that is, one that poses an immediate and serious risk to health and safety. The effect of this, sir, is therefore that minority ethnic communities are disproportionately at risk from hazardous living conditions due to an unavoidable need to rely on social housing. As such, not only was race crucially relevant to the disaster in the context of social housing, but also to the attitudes of those engaged in fighting the fire and those providing relief to the survivors. We told you previously, sir, of a comment made in an article in March 2021, the head of the London Fire Brigade, Andy Rowe. He told The Guardian that, quote, a culture of casual racism and misogyny remains so prevalent within pockets of the organisation that he feared his mixed heritage daughter might not be treated with dignity and respect at some fire stations. The Westway Trust, a charity involved with assisting Residents in the aftermath of the disaster said it accepted the findings of the review by the Tutu Foundation in 2020 that the charity has been and remains institutionally racist. The Foundation's report further found that, quote, the Grenfell fire brought into the wider public domain the long-held accusations by the local community that the RBKC had failed to listen to their repeated concerns, which they believed was as a result of institutional racism, historic disenfranchisement, marginalisation and inequality. Our clients find it astonishing, sir, astonishing, that given the history of the tower, you, the panel, have persistently refused to consider this vital issue. Our clients implore you, appeal to you, that you still have both time and opportunity to rectify this failure by applying Sir William Macpherson's definition of institutional racism, referred to earlier. It's not to point a finger at any one individual that they're racist. The definition is clear, and it's worth repeating. Quote, the collective failure of an organisation to provide an appropriate and professional service to people because of their colour, culture, or ethnic origin. It can be seen or detected in processes, attitudes, and behaviour that amount to discrimination through prejudice, ignorance, thoughtlessness, and racist stereotyping, which disadvantage minority ethnic people. In applying this definition to the conduct of those organisations involved, our clients ask you to find that institutional racism infected every aspect of the disaster, from who was placed in the tower to how they were treated during and after the fire. The sad, unavoidable truth is that racism contributed to the loss of 72 lives. Our clients urge you to make this finding. Nothing less than this will do. The second issue we address is foreseeability. We submit that the disaster was not only foreseeable, but foreseen by the many public and private sector institutions and individuals involved. As this inquiry has heard, cladding fires of this nature are not a new occurrence. Mr. Mansfield KC already referred to the Summerland fire in 1973 on the Isle of Man. 50 people died, and a further 80 were seriously injured. There has been recommendation after recommendation. There's been Knowsley Heights in Liverpool in 91, Garnock Court in Scotland in 99, Harrow Court in Stevenage, Hertfordshire in 2005, and Lackland House in London in 2009. Since Summerland and the multitude of fires in between that date and Grenfell, the position is best summed up by MP Harriet Harman, speaking in relation to the fire at Lackland House, and she said this, quote, whatever all of us did, it wasn't enough. Because if you've got something that happened and 6 people died, and then exactly the same happens again and even more people died, then none of us did enough. Whether it was me as a local MP or whether it was the ministers or people heading up the fire brigade, none of us did enough. Our clients ask that you make a finding, perhaps the easiest of the findings that you can make, that the fire on the 14th of June was both foreseeable and foreseen by those involved in its refurbishment, with greed in the form of cost-cutting, profit being the key motivator, leading to, at one point, we indicated at least 15 readily identifiable opportunities where components of the cladding used on the tower could and should have been identified as unsafe. All of the correspondence and information gathered for this inquiry demonstrate that cost-cutting, profit, greed was prioritised at the expense of the quality of the work and far above any consideration of our clients' safety and the importance of their lives. As is commonplace in the private sector, there existed, quote, a callous indifference to anything, morality, honesty, life safety, that was not related to the bottom line of the business. This meant that corners were cut, avoidable errors were made at every single stage of the works from conception all the way through to completion. The fact is that this should not have happened in the wealthiest borough in the country. Long chains of subcontracting gave everyone involved a false sense of security that even if they made mistakes, others in the chain could compensate for their shortcomings. perhaps the most troubling aspect was that for many of those working in those long, complex chains of subcontracting, the question of whether they were at fault was not even considered. As Robert Booth again noted in the 2022 article, quote, "The sociologist Zygmunt Bauman once wrote that violence in our age is defined by distance. Summarizing Bauman's idea, the journalist Daniel Trillig has written that this means not only physical distance, but the social and psychological distance produced by complex systems in which it seems everybody and nobody is complicit." The buck passing we've heard about from Mr. Williamson, King's Counsel. This theory may provide at least some explanation of why such a large number of individuals and institutions made a slew of fatal errors, despite being fully aware of the dangerousness of their decisions. As Booth noted, this is the reason why, until we change the way our society is organised, it might happen again. And our clients say it's not a question of whether a fire like Grenfell might happen again. It is for them a question of when it will happen. And it's only if we change the way our society is organised can we possibly have any chance of such a disaster not happening again. And for that to happen, our clients seek recommendations in relation to increased state regulation of the housing industry. Because as you're aware, consecutive governments, particularly from the latter half of the 20th century onwards, have pledged to cut red tape, reduce regulation on industry and free companies. The recent history of building regulations shows that the flagrant disregard for the health and safety of residents has been institutionalized. It has produced a culture which engenders a race to the bottom, caused by ignorance, indifference, and because they do not facilitate good practice. Accordingly, it's vital for recommendations to be made such that the state properly regulates the construction industry to ensure that homes do not become flammable death traps, rather than to leave this matter to the mercy of the markets, which has been the case until now. The third matter, discrete matter, our clients seek to address you on through me, is in terms of implementation of the recommendations. Mr. Mansfield, King's Counsel, has already addressed you on some parts of it. The starting point in our submission is from the case of R.V. Secretary of State for the Home Department ex parte Amin, when Lord Bingham spoke of the purpose of holding an inquiry into the death, in that case, of Zahid Mubarak, who was murdered in his cell at Feltham in March 2000. Lord Bingham stated in that case an inquiry was required, quote, to ensure so far as possible that the full facts are brought to light, that culpable and discreditable conduct is exposed and brought to public notice, that suspicion of deliberate wrongdoing, if unjustified, is allayed, that dangerous practices and procedures are rectified, and that those who have lost their loved ones may at least have the satisfaction of knowing that lessons learned from his death may save the lives of others. Now, those were precious words uttered in 2003. In the context of this inquiry, our client suggests that culpable and discreditable conduct has been plainly and uncontrovertibly exposed. And there's not just been suspicion of deliberate wrongdoing, but actual evidence of the same. What then remains now? Well, it's making the findings official and making recommendations which ensure that the dangerous practices and procedures which have clearly been identified during the course of the inquiry are rectified for the future. Only then will those who've lost loved ones and those who've suffered in other ways, will have the satisfaction of knowing that lessons learned from the disaster may save the lives of others. That, Chair, members of the panel, is a heavy burden that you and your colleagues bear and are required to discharge. You may be aware of a report published in December 2017 by the Institute of Government, which found that over the years, the inquiry has become the gold standard when it comes to independent investigations of disasters such as Grenfell. We have 3 or 4 happening as we speak, one here only a few weeks ago. The report identified that 638.9 million has been spent by central and devolved governments on more than 68 public inquiries since 1990. In late 2010, there were as many as 15 inquiries taking place at the same time. However, despite becoming the choice method of independent investigation, their efficiency has been inadequate. Since 1990, it has taken an average of 2.5 years for reports to be produced, and for at least 9 inquiries, it's taken 5 years or more. We're in that category. Within the 60 inquiry reports received by the UK and devolved governments between 1990 and 2017, there were at least 2,625 recommendations for change. Of the 68 inquiries that have taken place since 1990, only six have received a follow-up by a select committee to ensure that the government has acted. What the report found was that overall, the formal checks and procedures we have in place to ensure that public inquiry lead to change are inadequate. There's no routine procedure for holding government to account for promises made in the aftermath of inquiries. The implementation of recommendations is patchy. In some cases, repeat incidents have occurred, and there's no system for allowing inquiries to build on the learning of their predecessors. How much money has been spent on this inquiry? And how do we ensure that that money is well spent so that there is real change for the future? The report states that even in cases where government decides not to implement change, a process of government being called to explain its decisions is appropriate, not least that members of the public who have been directly involved in the inquiry understand why change has not been taken forward. We've already listed a number of fatal fires which preceded in our written submissions. I referred to them earlier. The most disturbing aspect of these incidents is perhaps a lack of meaningful action by responsible institutions to prevent future loss of life. It appears that those in power simply dither and dawdle, waiting for these events to dissolve from public consciousness. Who remembers Summerland in 1973, for example? So those in power can evade taking any remedial action to prevent future disasters. Summerland 73, Knowsley Heights, Garnet Court, Harrow Court, Lacanau House. So our clients ask, given that these events have happened time and time again, and recommendations made time and time again, and legislation changed time and time again, what could this inquiry do, which previous inquiries have not been able to do? The reality is that whilst recommendations from the inquiry will go, it is hoped some way to making buildings more secure. The fact is that if property remains a valuable commodity and is treated as a means to make a profit, corners will still be cut, and the dangers that exist today will still be the dangers that exist tomorrow and the dangers that exist in the future. Lives will be lost unless change occurs. And we're not asking the kind of change which is no more than at best second-order change. That is an adjustment of policy and practice, wholesale change, a change of the overall paradigm, not a tinkering of it. Now, whilst Chair, panel members, you may feel at unease at addressing what might be seen as a political part of the process, our clients have come to the inexorable conclusion that it's only when social inequality is entirely removed from the housing sector can they and their children truly sleep safely in their beds. And it'll be a matter for you and your colleagues to determine how much and in what way your recommendations can deal with this issue. Whatever your recommendations are, we have grave concerns that this government in particular and successive governments in the future, of whatever persuasion, will implement what you recommend. So, to ensure public inquiries can lead to real change, we refer again to the 2017 Institute of Government report, which referred to a need to have some form of monitoring mechanism. You've had some suggestions from Mr. Mansfield KC. We propose and ask that you take up what inquests have recommended, a setting up of a national oversight mechanism. And to go on from what Mr. Mansfield said about the Lawrence recommendations and the committee that was set up, which was attended by Mr. and Mrs. Lawrence, the Labour government soon disbanded it, forgotten about. And it's one of those scenarios where everyone assumed after the Lawrence and Macpherson recommendations that, well, we've now dealt with the issue of race. We have a report, we have recommendations, that's done and dusted. That is not what we want to happen in this case. A national oversight mechanism to examine regular progress on the state of implementation of the recommendations of the inquiry. An inquest campaign to establish such a mechanism says this, is to, quote, ensure that recommendations arising from inquiries, inquests and investigations into avoidable deaths are implemented. This would mean that once recommendations are made, an independent body would monitor and hold state and public bodies accountable for their decisions in response to recommendations. Not only this, but our view is it should go further. It's not, we say, simply a question of asking and giving 28 days to find out whether recommendations have been made or what progress is made, but to punish and have punitive measures for those who don't comply with those obligations, those responsibilities. It's to ensure that organisations are not allowed to continue their egregious evasion of responsibility. Our clients truly hope that this inquiry does not prove to be yet another administrative formality or box-ticking exercise. So, at Summerland, 50 died. At Garnet Court, 1 died. At Harrow Court, 3 died. At Lakenham House, 6 died. At Grenfell Tower, 72 died. As it stands, it's not a question of if, but merely when and where the next fire will occur and how many will die. Our clients' hope is that when this inquiry concludes, they and their families can be confident that your recommendations constitute a genuine attempt to put an end to this fatal line of history. Moving on, much has been said by the lawyers for the court participants who are not bereaved survivors or residents, including what might have been intended as an apology for their acts, omission and failures. Whilst I haven't seen what will be in their closing remarks, it seems to our clients that what is now required from each of them is an unequivocal, unambiguous and forthright apology for their part in the disaster. And we look forward to those apologies when each of the lawyers makes their closing submissions. As Sir William Macpherson rightly said, unless there is recognition from those who failed, recognition, acknowledgement and acceptance of the problem, it cannot be solved. We look forward to, say, each and every legal representative on behalf of these clients to make that apology during their closing remarks. And in the event that any does not, our clients will consider this to be injustice heaped upon injustice and a mark of disrespect. Finally, sir, we have been specifically asked to repeat that which was said at the 5th Memorial Commemoration at Westminster Hall, because it bears repeating. We set out a part of what was said, which we have rephrased for today. After this inquiry has finished and reported, you, each of us, all of us, will go back to our homes and offices and back to our work, whilst our clients will go back to empty houses, not homes. Their actual homes were destroyed in the fire, houses that are missing family photographs and heirlooms. We, all of us, will see our family and loved ones. The bereaved will be haunted by the memory of theirs. No longer will they be able to embrace their family members, tuck their children into bed, read them a bedtime story, or have a family meal around the dinner table. Every morning they will have to wake up to an empty bed and aching heart, knowing that they won't be taking their child to school or teach them how to ride a bike or swim. No longer will they attend parents' evening or see the smile on their children's faces when they pass their first exams or driving tests. No longer will they see their child graduate from university or get married. They will be haunted daily with the guilt of what more they could or should have done to save the life of their loved one. No parent should outlive their child. No parent should be deprived of the joy and wonder of seeing their child grow up and care for them when they themselves get old. This, all of this, has been lost to so many people, and all because of a fire that could and should have been avoided. And if this was not enough, our clients have had to suffer the indignity and pain of having to fight for justice within this inquiry, with the Metropolitan Police and with those who are legally responsible. And what does this justice look like? Our clients are clear. If nothing changes, their loved ones will have died in vain, and they're not prepared to accept that. They want wholesale change to the housing sector in this country so that there is safe and suitable housing for all, not just the white, able-bodied and wealthy. They want meaningful recommendations to come from this inquiry, and they want those recommendations implemented in full and in a timely manner. They want the law to change, that those who are considered criminally culpable are swiftly prosecuted and properly punished. They want those who are responsible for failures to be forced to accept responsibility at the outset, rather than playing the blame game, as almost every party has done during the inquiry. And when tragedies such as this occur, and they will, when everyone knows what happened and why it happened and who was at fault, they don't want the victims to have to wait for half a decade, as they've had to do here. They also want the 14th of June to become a national day to memorialise the Grenfell Tower fire, so it is a lasting and permanent legacy of something that is never forgotten, so that it cannot be forgotten. So our last plea, on behalf of our clients panel, is for you to recommend the 14th of June a National Day of Remembrance, so that this disaster, this tragedy, and those that suffered so much are never, ever forgotten. Thank you.
Thank you very much, Mr. Gunn. Well, it's 5 minutes to 1. I think that's a good point at which we break for the morning. We'll resume, please, at 2 o'clock. Thank you very much.